social care charging for social care in the community. Before we start, so just to say that we have interpreters, and we are streaming this to YouTube and recording. So when you put questions, kind of think about what you want other people to see and know. Secondly, we wanted to say that this is not legal advice session. This session is delivered by me, Svetlana at Inclusion London, and Jenny Hurst from Action Disability Kensington and Chelsea, and we based it on our experience supporting people to challenge their financial assessments. So if you do need legal advice, there is a list of lawyers on our website that you could contact for legal advice about your individual case. If you have a question for us, we ask you to please post it in question and answer section, because we're going to try and answer questions as we go along, so we can answer as many as we can. And that's probably it. So we're gonna move to, okay. So this is planned for today. We're gonna talk a little bit about the legal framework, so what the law says about financial assessments, and what law you could look at if you need to know more or want to challenge. Then we will talk about what financial assessments are, what the process is, what are your rights, and what local authorities should be doing. This will be my part. Then we'll have a little access break. And after that, Jenny will take over and she will talk about disability related expenditure and how to challenge assessments. And then after that, we'll have a little access break. And then we will talk about the High Court judgment in SH case, the recent judgment, and how it could be used in individual cases and how it could be used to challenge charging policies. So now this is what's the law about charging. This is the law. So first, it's the Care Act itself. In section 14, it gives local authorities power to charge, which means that local authorities can decide what they do, whether they charge people for social care support in community or not. It's quite different for residential care, but we're not talking about it at the moment. Then that section also sets out some requirements. For example, things like local authorities shouldn't charge more than what it costs them to meet persons' needs and things like that. Then section 17 talks about financial assessment, that that local authority must do financial assessment if it wants to charge, and that regulations will set out how it should be done. And then there are also sections 69 and 70, which basically allow local authority to recover charges that person hasn't paid as a debt. Then the next bit that is of law. So just to say that Care Act is the law and local authority must follow it. So if local authority does something that contradicts what the Care Act says, it is breaching the law. And if this applies to kind of your situation, that you really need to get legal advice. And we will be saying today, but it's worth repeating many times, that legal aid is available for those cases. So you can potentially get legal advice for free. So the next bit of law is the care and support charging and assessment regulations. The regulations give great detail of how financial assessments should be done. They set out capital and income thresholds, and they have lists of exclusions and so on. So again, this is what we call hard law. Local authorities must follow it. Then there is Care Act guidance, the statutory guidance, which is more of a document that is written in a human language. And I personally suggest, and I know many of you don't really have time to do this, but if you really want to challenge something, this document is really worth reading, because it's quite fairly easy to understand, and you can refer to specific points in this guidance when you communicate with local authority. Local authority again has to follow this guidance, although they can sometimes depart from it if they have very good reason not to follow it, but obviously they would have to justify doing it. Usually local authorities follow this guidance. So it's in this case, when we talk about assessment, financial assessment, you'll be looking at Section 8 and Annexes B and C. Then there is local authority circular, which Department of Health issues every year, and basically the purpose of this is to update the thresholds for capital, for minimum income guarantee, and so on. And the most important piece of kind of well, it's called law, but it's not really law. What the most important document, which will actually say how your assessment will be carried out, is your local authority's charging policy. So when you're going through financial assessment, it's really worth opening that charging policy, finding it. It must be on their website, and looking how they said they would do things. So there are some requirements that the law set about charging policy. So first of all, local authorities' policy must follow the Care Act regulations and the guidance. So when they design policy, they must kind of follow the law. And that doesn't only, it's not only limited to the Care Act. They, for example, have to comply with other bits of law, like the Equality Act, so make sure it's not discriminating against disabled people, or and they have to make sure they comply with the Human Rights Act. So when we talk later today about SH judgment, we will kind of talk about how local authorities' charging policy might not comply with the Human Rights Act, and what we can do about it. So the guidance and regulations set only minimum standards, and when it comes to charging for care in community, local authorities can be more generous, and actually they should consider being more generous, especially taking into account kind of local situation. So the guidance, care and support guidance, says that charging policies should promote well-being and social inclusion, support choice, control, and independence, and encourage people stay in or take up work or training or plan to do those. So obviously, when we look at charging policies, we should remember this and kind of ask how that promotes well-being and independence and choice and control. And when local authorities make changes to their charging policies, and we notice that many of them do make those changes to effectively charge people more, they have to consult about the changes with the public. So if that is not happening, it's something that, again, we suggest local groups of people or campaigners take legal advice about. So just very quickly to illustrate where financial assessment sits in the Care Act process. So first of all, local authority must assess needs, and they assess all the needs, look at all the needs. Then they make decision whether person is eligible for support under the eligibility criteria. Then they supposed to design together with the person their care and support plan. And then they do financial assessment. So financial assessment happens at a time where they know they're going to do something to meet your needs. They're going to meet them in the community, and then they start asking you for all the information about your finances. And then obviously they have to meet needs. So in response to one question that we had, it's important to clarify that when financial assessment has been done, you have to pay your contribution. Well, you can dispute the amounts, but you kind of have to pay your contribution. You cannot, for example, if you use direct payments, you cannot, for example, have a situation where you just spend few hours and save up your direct payment money to cover your contribution. It doesn't work like that. Local authority will try and then pursue you and try and kind of recover that. So if you don't agree with your financial assessment, you have to dispute that assessment. And if you kind of, for whatever reason, choose not to pay your contribution, you are taking a risk. So you need to be aware of that. These are the things that local authority cannot charge for. So when they decide to meet your needs, if it is about reablement services, and reablement services are usually time limited, usually 8 weeks, but it could be extended. And the purpose is either to kind of help person to, well, it usually happens after person was admitted to hospital or major change in their situation. So they kind of learn how to live with their new support needs. Then equipment, which aids and appliances costing less than £1,000. They cannot charge for assessments of and care planning. So they can only charge for what it costs to meet the needs. They cannot charge for services that do not constitute meeting needs under the Care Act. And they cannot charge for aftercare services. So aftercare services are provided to people who were detained under the Mental Health Act, and then they've been discharged, and services are aimed at kind of supporting them in the community and preventing further detentions. So this support then should be given for free. Couple of words about charging carers. So although it may sound shocking for some of us, local authority can also charge carers for support that it gives them. And again, the same as with disabled people, they would have to do a financial assessment of carers' finances if they decide to charge. Financial assessments, the guidance says that they kind of have to take into account the carers' well-being, and the care need to continue to care their carers' safety and so on. So effectively, it's probably a hint that local authorities need to think hard before they charge carers and how they ask them to pay. The important clarification note is about respite. So effectively, when service is provided to carer to meet their needs, then carer will be charged for that. But if a service is provided to a person, like a respite care, it will be a person who will be charged for that service, not the carer. Okay, so moving on to financial assessments. Here are some very headline things that you should all know. If local authority decides to charge, it must do financial assessment. It can sometimes backdate that charge if financial assessment, for example, takes long time to do, but it has to give person enough information so they understand that social care is not free. They might be asked to pay for it, and kind of so they agree to get the service knowing that they might have to pay for it. People should only be charged what they can afford. And we will, the government has kind of defined what they mean by that. So in a few slides down, we will talk about what exactly government thinks people can afford to pay. Local authority must financially assess the person. So if person is a member of household and other people are members of that household, for example, if you're a couple, they have to only look at your finances, not touching finances of your partner or spouse. Local authority must complete financial assessment and provide you with a written record. And we would say the process must be accessible, because local authority also has duties under the Equality Act to make reasonable adjustments. So they, for example, should provide information in accessible formats and make reasonable adjustments to make sure the person can participate in the assessment process. Then they should give you a written record of their calculation. Again, in the format that is accessible to you, so you can clearly understand how they've calculated what you should pay, and you kind of really understand how much you should pay. So local authority cannot charge you more than what it costs them to provide this service. And this is clearly said in the Care Act itself. So if there are local authorities that do that, it's completely unlawful, and you should challenge this. Local authority must leave you with enough money to live on, which is kind of called base, and they should also disregard your disability related costs. So what they look at when they do financial assessment: first, they would look at your capital, then they would look at your income, and they would look at your expenditure. It sounds quite simple, but rules, of course, are complicated. So when we talk about capital, it's the capital, the Care and Support Statutory Guidance in Annex B kind of sets out what is capital and what should be treated as capital and what shouldn't. And the regulations and the local authority, that circular that Department of Health issues every year, they set out capital limits. So upper limit is £23,250. And if you have savings or stocks or whatever above this amount, you will be a self-funder, unless local authorities charging policy says otherwise. So you will effectively be asked to pay for your care in full until your capital reaches that, below that amount. Then there is lower limit, which is 14,250. Below that, all the savings or capital below that will be disregarded. But if you have capital above that lower limit, local authority will apply what's called tariff charge or tariff income on the sum that is above that lower limit. And the way they do it is they take £1. They assume you have £1 income per every £250. We have an example here. So if, for example, you have £16,100 on your bank account, then it will be 1,850 above the lower limit. So that divided by 250 will be 7. So local authority will assume that you have extra £7 of income every week. So now income and what should be disregarded. So it's kind of for some of us, it's quite those, especially people who are new to this, might be quite unbelievable that most benefits will count as income. Income other than earnings, so any regular kind of payments that you might get, and you might get also regular money from different trust funds that will also be classed as income. So I don't know, private pension, for example, in terms of like regular other income other than earnings, private pension, for example, could be that other income. But some income must be disregarded. And this is earnings, so from work, from paid, from employment and self-employment. It's mobility component of personal independence payment or disability living allowance, and so kind of some other benefits. Certain trusts, they may need to do with specific impairments, specific conditions that were just lobbied to put in those regulations. And obviously direct payments money shouldn't be classed as your income because it's not. You have to spend it on your care. Well, the principle and one of the key principles of this system is that person should be left with enough money to live on. We included this couple of statements from the Care and Support Guidance so you could look at and refer. But basically, keeping enough money to live on means that government sets out minimum income guarantee. So minimum income guarantee is the amount of money per week which person should be left with. And in addition to that, if local authority takes into account benefits, that extra cost benefits that disabled people get, so any your disability benefits like personal independence payment or disability living allowance or attendance allowance, your premiums like severe disability premiums, so on, if they do take that into account, they have to disregard your disability related costs, which Jenny is going to talk about later on during this session. So expenditure, and you just remember that this is your money, the money that you got, that you are effectively allowed to keep. This is how the system works. But what you should be allowed to keep, what they will deduct from your income, is your housing costs. So things like rent, mortgage, service charges, council tax, basic costs of living, minimum income guarantee, which I'll show you the amounts in a second, and as I said, disability related expenditure. So anything you have to spend money on because of your disability. So this is minimum income guarantee. So the CARE Act and the charging and assessment regulations say clearly that when local authority carries out financial assessments, they should leave people with minimum income, with amounts which are set in minimum income guarantee. So you will see that those amounts are, they do differ depending on age. So, and they consist of kind of several things. So first is basic allowance. It's similar to income support and other benefits, I suppose. So first, basic allowance, which young people get just £72, and people above pension age get £189 per week. This is all per week. Then they would add extra allowances. For example, if you look after a child or children, they would add money. And then if you under income support would have qualified for certain premiums, they will also add money as premium. So excuse me, disability premium and enhanced disability premium. So you could see that a person, for example, with young person with quite complex needs would get £72 plus £40 plus £19 per week. So that would be the money that the person would be allowed to keep to effectively live on. So just to recap, with financial assessment, so what local authority does. First, they look at your capital, and obviously if your capital is above upper threshold, they will just tell you to pay for your care unless local charging policy says otherwise, because as I said at the beginning, it's the national legal framework just sets out minimum standard, and they I don't know local authorities now that do that, except Hammersmith and Fulham that doesn't charge. But it doesn't mean that there aren't local authorities that might have higher capital thresholds. So then they will calculate the tariff income. Then they will identify all the income that you've got. They will deduct from that things that they have to disregard. So for example, your earnings or your mobility component of PIP or DLA. And then that they will deduct expenditure. So your housing costs, your disability related expenditure. And we know many local authorities, they have some allowances. So for example, they would allow £10 or £15 as standard for disability related expenditure. So they would do that, and that will get them to the amount which is they call maximum available amount to pay for your care. And then they will compare that with the cost of your care. And if the cost is kind of smaller than the amount that you can pay for your care, according to their assessment, then you will just have to pay whatever it costs to meet your needs. So how much your care costs. If the amount is bigger, then you'd have to pay what they say your maximum available amount to pay for care is. Just also to say one thing to be aware of, which often is quite difficult to understand. You will not necessarily reduce your charge by reducing your care. So sometimes people think that if they, for example, cut their hours, especially if they have quite few hours, and now probably there are not that many people who do have more than they need, but people think that if they cut their hours, they will automatically reduce the amount that they have to pay as a charge for care. And this is not correct. So you'd have to reduce your care below that maximum available amount that you've got. So the cost of care will have to be less than that for you to then reduce, and effectively you will be fully paying for your care as a result of that. So now I am going to stop sharing, and
and while I have the screen on, I'm going to switch my camera off so it's easier for me to look at the screen and read through my notes as well. So I hope that's okay with everyone. I'll switch the camera back on afterwards for the question and answer session. And I will share my screen. So I hope that screen is visible to everyone. So this is the second part of the session, and I am going to introduce myself. So as I've got the screen off, and for people who are not able to see me, I'm Jenny Hurst. I'm the Independent Living Coordinator, and I work at Action Disability Kensington and Chelsea. It's nice to see that there are a few of the Action Disability Kensington and Chelsea members with us today. So my photo on the screen is I'm a white woman with short dark hair. I wear glasses and I've got studs in my ears. And it's a head and shoulders shot. So the plan for my part of the session is to have a more detailed look at disability related expenditure, what can be included, how to argue for items that can be included as disability related expenditure. So disability related expenditure is also known as DRE, the initials. I'll also briefly talk about how to check and challenge financial assessments. So I'll go on to the next slide. So the statutory guidance, as Svetlana said, is the go-to document for understanding and implementing the CARE Act and the regulations. So Chapter 8 is specifically about the financial assessment and charging. And as Svetlana mentioned, one of the key points is 8.42, and that says, where a person receives benefits to meet their disability needs that do not meet eligibility criteria for the local authority care and support, the charging arrangements should ensure that they keep enough money to cover the cost of meeting those disability related expenses. So basically that means that if you're a disabled person and that you have certain needs and the council are not providing those needs, when you have the financial assessment, you must be left with enough money to cover those needs. So the difficulty is two people with the same benefits might have very similar needs, but have different costs. And this is sometimes why it can seem confusing why one person with the same benefits is charged and another person is not charged or has a lesser charge. So the key points are if you have disability living allowance, personal independence payment, or attendance allowance for care, then identifying your disability related expenditure is really the best way of avoiding being overcharged. Some local authorities look at disability related expenditure and financial assessment in different ways. So some local authorities might give an automatic allowance and there's no need to prove anything if your disability related expenditure is under that. But if you have increased disability related expenditure, then you'll have to offer proof. Some local authorities ask for proof every year. They do a full financial assessment every year. And some local authorities will increase the charge, give you the information, and leave it to you as an individual to challenge and to ask for a proper full disability related expenses assessment to be taken into account. So, what is disability related expenditure? Well, lots of local authorities send out information about what could be a disability related expenditure, or they ask about certain things in the financial assessment forms. There's no definitive list of what is or isn't a disability related expense. There are some things that would be accepted and other things that depend very much on an individual circumstance. So to prepare for a financial assessment, it's easy to look at disability related expenditure in 3 different ways. So money that you use to pay for specialist items or services, for example, that are only used by disabled people or people with a health condition. A second way of looking at things, so when you're trying to identify disability related expenses, is any extra money that you have to pay for a non-specialist item or service, which is either more expensive to you or you need to use more of this item or service. And the third way is to think about the money that you have to pay for everyday items or services that you have no choice about using because you're a disabled person or you have a health condition, but for other people, it might be a choice. So it's useful to look again at the Care Act Statutory Guidance, and then Annex C of that statutory guidance has a very good list, which lots of local authorities use to base their policies on and to base their documents on. So I've broken this down into the 3 sections. I've called this one specialist expenditure. So the Care Act Statutory Guidance, Annex C, has section 40. And there's a good long list that gives examples. And most people will recognise this type of list in documents that a local authority has given them, or a charging policy that they might have seen about what is and isn't counted as a disability-related expense. So going through them briefly, you have payment for a community alarm, cost of privately arranged care services, including respite care, and costs of specialist items that are needed to meet the person's disability needs. For example, and this for example is very important because the following list gives examples. They're not these are the only things that you can have, they're just examples. So with specialist items, they have day or night care, which is not being arranged by the local authority, specialist washing powders, sorry, my screen has disappeared. Oops. I apologize, my phone went and now I can't see the screen. I'm going to stop sharing and then reshare it again to see if I can get it back. I'm just sharing again. There we go. So I do apologize for that. I'm just going to turn my phone off. So yes, they're saying about specialist washing powders or laundry, additional costs of special dietary needs because of your illness or disability. And that's one of the key things. Many people say, oh, I'm spending money on this gluten-free bread. So one person might need the gluten-free bread because of celiac, and one person might choose to have gluten-free bread because they feel it's better for them. That's why it says the person may be asked for permission to approach their GP in cases of doubt. The next part is specialist clothing or footwear. For example, where this needs to be specially made. There's a second part of this, which I'll come to in the next slide, but that's specialist clothing or footwear. And the last point on this one is purchase or maintenance and repair of disability-related equipment. So again, there's a whole range of things that you could put down if you have the ability to have a bit of a think beforehand, if you're able to have access to the right information to allow you to have a think about what happens in your daily life, what type of expenses you have. So the next part I've put is the extra cost of non-specialist services. So it has things like any additional costs of the special dietary needs. So not only would it be a specialist piece of food, it might be any additional costs you have because of your special dietary needs. Again, that second part of the one that I mentioned earlier is additional wear and tear of clothing and footwear caused by disability. So it's not necessarily that you have to buy a specialist piece of clothing or footwear. It's if you have additional wear and tear, so you have to purchase more of whatever piece of clothing than another person. That's also counted as a disability-related expense. And the same with costs of bedding. They have here additional costs of bedding because of incontinence. So they would look at how many items of bedding someone who doesn't have your impairment would pay. And if you have to buy more than that, they would take the difference. And the last part on this slide is any heating costs or metered costs of water above average levels for their area and housing type. So this is important in a number of ways. So if you happen to be a thrifty person and then you became disabled and your expenses have gone up, unfortunately, it doesn't help you. A lot of local authorities will look at something called the National Association of Financial Assessment Officers Guidelines, and they will say, in this area, it tends to a family tend to pay this amount, or a single person would pay this amount for water costs or for heating costs. And then if you have greater than that cost, they would look at the difference between what it costs for the average person and what it costs for you. The next slide here, I think, is particularly important. There's three things that I'd love to pick out. Firstly, is that you can have a disability-related expense occasioned by age, medical condition, or disability. So that is, as you're a disabled person, if you need to spend extra because of your age, medical condition, or disability, it can be counted as a disability-related expense. Now, that's particularly important as we saw previously, charging policies are supposed to promote well-being and social inclusion. So the Care Act Statutory Guidance 8.2 said the approach for charging for care should promote well-being, social inclusion, encourage people who wish to take up employment, education, training, or plan for future costs to do so. And if you need to spend any additional money on those things because you're a disabled person or you're frail because of age or your medical condition, it's a disability-related expense. It doesn't have to be purely practical things. It can be something like leisure activities, it could be therapies. So that's a really important point there. It's one to remember to argue if your disability-related expenses are not accepted. So underneath that, you have the basic costs of garden maintenance or cleaning or domestic help. If you need to have that because you're a disabled person, and especially because those services are not met by social services. So if you have your care needs assessment and the social services say, oh, well, we don't provide this type of service or that type of service. First of all, challenge that. But second of all, make sure you can spend your money on meeting those needs that the council won't meet for you. The next one down is the purchase and maintenance of and repair of disability related equipment. So if you have a piece of equipment that you've had to buy privately and you have an ongoing maintenance contract with someone, if you need to repair that piece of equipment and it can't be repaired for free, that's a disability related expense. And further down that same paragraph, it says reasonable hire costs of any equipment can be included if you're waiting for the supply of that equipment from the local council. So if you are on a waiting list for an OT assessment and you need to hire a piece of equipment in the meantime, make sure that you identify that as a disability related expense to the social services. The next point is personal assistance costs, including any household or other necessary costs arising for the person. So if you employ someone, do you have to buy extra hand soap, extra toilet roll, extra tea or coffee? If you have a living care package, are you having to pay for the cost of the meals for that personal assistant? If so, and it's not included in your care package, it's a disability related expenditure. Going on to the next, the last two, we have internet access, for example, for blind and partially sighted people. And I'm picking up for example here. So I've seen some policies where it says, if you're a blind or partially sighted person, we will allow you the cost of internet access. But it says, for example, so that doesn't mean only people who are visually impaired. You can argue that. And finally on this slide, transport costs that are necessitated by illness or disability, including costs of transport to day centres over and above the mobility component of DLA or PIP, if in payment and available for these costs. So local authorities are not allowed to take a mobility component into account when they're looking at charging you. And if all of your mobility component of DLA or PIP is already used, for example, you're having to pay the full amount for your mobility vehicle, then ask the council to look at petrol costs for essential visits to the day centre or doctors or hospital appointments or leisure activities that support your well-being and inclusion. As we said before, it's vital to check local policies because the statutory guidance in that same section, section 40 of Annex C, says that in some cases it may be reasonable for the council not to allow for items where a reasonable alternative is available at a lesser cost. And they give an example. For example, a council might adopt a policy not to allow for the purchase of private purchase of continence pads where these are available from the local authority. But they may also say in their policy that it's the same thing for equipment that you might be able to get from the occupational therapist for free, or you might be able to get a wheelchair or mobility aid from wheelchair services through the NHS or through the physiotherapist. They might say, we think you can get cheaper electricity or cheaper heating costs. If you say, oh, I need to save up some money for a mobility car, they might say, oh, well, there are some free ones that without any down payment. So we wouldn't necessarily allow that. So some things that you might hear or see or be told is that we don't take that type of expense into account, or that expense is already covered by the minimum income guarantee, or we allow a maximum of X pounds for that type of expense, you can get it free from the NHS or a cheaper version from wherever. And that's a lifestyle choice, not a disability need. Or someone else paid, not you, or you haven't paid yet. So these are all things that we're going to look at in a bit. So when you're asking to have disability related expenditure taken into account, local authorities will often ask for financial proof and proof of need to spend the money or why it's reasonable to spend money. So you may be asked to provide receipts or show invoices that you've already paid. That shows that you've already spent the money. This can be very difficult because not many people store up months and months of receipts, and local authorities have a number of different ways of dealing with financial assessments. So people might be asked to pay the full cost and then provide the receipts going forward. So next 3 months worth of receipts to prove that expenditure. But it would be useful to argue then, if you're charged the full amount, how are you going to have that money left over for you to be able to spend money to get the invoices and the receipts that they're asking for? If you have a hire purchase agreement or a credit agreement, it shows that you're expected to make payments for a number of weeks or months into the future. So that can be used to prove that you're going to be making those costs. And if it's for a disability related expenditure, such as if you're purchasing a vehicle that's adapted, or you have a recliner chair that you're paying off in monthly intervals on a credit agreement, that shows that it's a disability related expenditure. Again, maintenance contract or service contract, if you have a piece of disability equipment and they need to come out and service it every so often, that's something that is almost a guaranteed sum that you'll need to be able to have to pay for that. I've next put payroll documents, because some people will pay for the additional care and support or the help to do the garden or the windows. And it's tempting for some people to say, oh, you know, I gave a £5 to my grandson who helped me do that, or I give my neighbour £20 a week to do whatever for me. Unfortunately, local authorities aren't allowed to support cash under the counter. So it has to be either someone who gives you an invoice and you pay the invoice, or you put that person on the payroll, which is a really unfortunate situation. But sometimes it's a lot easier to have a neighbour or a friend do something for a bit of a gift. And also to get comparison websites or quotes to say, this is what the cost of the energy is in my area. In terms of proving need or reasonableness, ask a GP or a consultant, or it can be someone like a herbalist or an acupuncturist, someone who has a qualification in a medical related background. If you can get a support statement from a family member, personal assistant, or support worker, that's good. Some people have used leaflets or printouts from condition-specific websites to say, oh, on this website, it says Swimming is a good form of exercise for a person with my condition. So I want to have a disability related expense in terms of this cost of a swimming pass, or this website says crochet is good for my condition, or this website says whatever supplement is good for my condition. So that's useful. And the same with research papers and statistics. It's all good evidence to show why you're asking for that type of disability related expenditure. So checking and challenging financial assessments. With the financial assessment itself, it's easier to get hold of the assessment breakdown, ask for an accessible copy, something that you understand, and check the figures. So is the savings amount correct, or have they charged you too much of that tariff charge, the £1 per £250 savings above a certain amount? Have they got the correct benefit rates in there? Have you got a court order saying that money's stopped from your benefits, so you don't actually get the full amount in? That has to be taken into account. You're only able to pay, you can only be charged what you're reasonably able to pay. So for people with universal credit, this is one of the benefits that can be taken into account. And for some people who are working, they may have issues where they get universal credit 1 month and they don't the next month because their wages are paid every 4 weeks. If you do get if you have income that must be disregarded, and again, that's all in Annex C of the Statutory Guidance. Make sure that's all correct, and check whether the minimum income guarantee that Svetlana told you about earlier, whether that's correct. Have they made sure all of the figures on there that suit your circumstances have been included? Likewise, anything you pay for housing or council tax, and also the disability related expenses, are they correct? And finally, one of the things that's that sometimes slips in is about the cost of your care. So especially during the pandemic, where people haven't been able to access all the support that they have, all the support that they've been assessed as needing, check that you're not paying more than the actual support that you're getting, the actual amount that the council are paying for your support. And about any refused disability-related expenditure, ask for a full breakdown of the disability-related expenditure, because sometimes there's just a summary, just a single line with a total amount that the council have agreed. So if there isn't a full breakdown, ask for that. And again, see if there's any errors in calculations or missing information, and ask the council to rectify that if there are miscalculations. If the council have asked you to provide receipts for the next several months, provide those receipts if you can get them, and ask them to recalculate. If you're unhappy, you can ask for a review, and that can be from a different team, or that could be from a financial assessment team in another local authority who look at the same policy that your local authority use. And if you have any additional disability-related expenses, put those in. If some disability-related expenses are not allowed, ask in writing for it to be explained why, and ask them to reconsider after you've given an explanation. and also quote policy and legislation. So use those little bits in the Care Act statutory guidance about not being asked to pay more than you can afford, or that the local authorities are supposed to support well-being and social inclusion. If you've been asked to pay the full amount and then give receipts when you get them, ask to be considered under a hardship policy. You're not going to be able to get the receipts if you're having to pay all of your money to the charging. And of course, if you're still dissatisfied, you can always go to the local government ombudsman, which takes a good while, or involve a solicitor. So the next couple of slides, I've got some reasons that you can use, and I think the slides will be available. So depending on an excuse that you're given, so if you have, if you're told you could get a cheaper version elsewhere, it might be, is it actually available locally? Is it available to that person? Is it suitable for that person, this cheaper alternative? Or is there a long wait to get a cheaper alternative? If the local authority says, you can get this from wherever, or this other place is supposed to provide that, have you been able to access the assessment? Or is there too long a wait? Has that person been denied the access to the free version, or is that suitable? Would the person be eligible for a grant or a service if the local authority say that's what you should be doing? We've heard about the statutory allowance, or the minimum income guarantee, that the government has said is enough to meet people's daily living needs. So is that relevant if the council say, oh, the government allowance already covers that? Is that relevant? Have you had to buy something extra for coordinating care and support, such as a mobile phone, for example? That's additionally an additional thing to what people would usually have to pay for. Again, the household expenses of having a personal assistant, or if you've had to buy a new piece of equipment, or upgrade a piece of equipment so you can use it with a disability related program, for example, on a computer. And if they say if it's a lifestyle choice, well, what are the medical or disability related reasons for buying it from a certain shop or choosing that item? If a non-disabled person was denied this expenditure, would that be reasonable? If local authorities ask for disability related expenditure to be written or noted in the care needs assessment, has your assessment been holistic? What type of psychological effects or emotional well-being or physical improvements would that piece of expenditure provide you? If you haven't been able to show that you've personally paid, did another person have to pay for a reason, such as you've got no credit card or online access? And how are you going to pay that person back? Is there a pattern of repayments, or a statement from another person saying that they had to pay and you're paying them back? And I know this is a really difficult thing, but when councils ask for receipts, there are some transactions that we make as disabled people, or as people in general, which are cash only transactions. So sometimes you'll go to the hairdressers and they just put it in the till, they give you the change back and there's no receipt. Or if you use a cab, sometimes they don't have a receipt book. So, or if you have lack of admin support to help you compile all the receipts. And a local authority financial assessment officer might say, well, you haven't paid yet. So are you having to pay money, put money aside for when a payment becomes due? So is there a pattern of savings, like, for example, 3 yearly deposit for a motability vehicle? That's something that you need to be able to save up for. And again, what will the effect of disallowing the savings for the disability related expense have? And we're getting near the end. So for transport costs, a lot of local authorities will always say you're getting a mobility allowance for that, so we don't allow it. But do you actually get the mobility allowance, or has that been stopped? Are you waiting for an appeal because you've had an assessment? Is it already being used in part or in full? So have you got that motability vehicle and you're having to pay all of your mobility component to that? So if you have used up all your mobility allowance, fuel is an additional cost. I've put here, especially on a large or heavily adapted vehicle. If you've been given a partial grant, or is there a deposit needed? Again, those are things that you need to build up to be able to pay. So you haven't paid it yet, but you will need to pay it. Same with adaptations and the insurance. If you're not able to have an open policy on your motability vehicle, you might have to pay additional amounts to have that third driver. So they might say there's another service you can use, but have you been denied a Freedom Pass or taxi card or dial-a-ride membership? Do they exist where you are? Do the free services run at the time of day required? And are they actually chargeable costs? And you can also explain why public transport or hospital transport or day centre transport is unsuitable for you, and that's why you have to pay. So finally, there's the points that you can use to challenge the charging policy as a whole. And again, that's in the Care Act Statutory Guidance, Chapter 8. So 8.46 says the government considers that it's inconsistent with promoting independent living to assume without further consideration that all of a person's income above the minimum income guarantee is available to be taken as charges. So basically, taking the last bit of money that you have, which is allowable by the government, is not consistent with independent living. And the next 2 points are suggestions that local authorities should take into account when they make their charging policies. And that's whether to consider if it's appropriate to set a maximum percentage of disposable income. And that's over and above the guaranteed minimum income, which may be taken into account, which is 8.47. And finally, 8.48 is that local authorities should consider whether it's appropriate to set a maximum charge. For example, this might be set as a maximum percentage of care home charges in the area. This could help ensure that people are encouraged to remain in their own homes, promoting individual well-being and independence. So those are 3 points that a campaign group or individuals could go back to the council and say, we would like you to look at your charging policy. And I think there's going to be more about that after the break. So the last page is the references and links for the CARE Act, the Care and Support Charging Assessment regulations, the Section 8 that I've been talking about, Annex B, which Svetlana talked about, Annex C, which I mentioned with that long list, and the current rates, which were put around in the local authority circular. So that's the end of my presentation. Thank you for listening. And I'll hand back to Svetlana.
Okay, thanks. Thanks, Jenny. We are going to try and take another access break, and then after that, as I said, we will talk about Norfolk case, and then we will try and answer questions. I think we've been trying to answer questions, but there are some themes that are well coming through, so maybe we could just look at some of those themes. We'll just take access break until 20 past.
View from Justice Griffiths, so to make sure that Norfolk County Council actually fulfil all the findings in there, and it's done in a co-produced way, and we have a policy, charging policy that's actually fit for purpose. In terms of the judgment itself, I won't go into massive amounts of detail because there are some good summaries, and I'm sure Svetlana and others will add some detail, but essentially it meant that SH, and who's a disabled young woman from Norfolk in receipt of personal budget direct payments, was unfairly disadvantaged and discriminated against in terms of charging policy. Means that anyone in the cohort who's receiving either enhanced levels of personal independence payment or support group of ESA don't have the ability, or have higher benefits and therefore charges, don't have the opportunity to offset these with paid work. So that means they're unfairly discriminated, and there's not a chance for independent living, and it's greatly reduced by the charging. So Norfolk has now got to introduce a policy that does not discriminate, and that's why we've formed as a task and finish group, as I say, user-led. We're run, our committee and group is run for and by disabled people in Norfolk affected by this situation. The judicial review does apply to the rest of the country, and there's some guidance from Lead and Cascada and other organisations that's been put together. So it definitely does apply to other areas of the country. And, you know, I would really encourage anyone today who's affected by this to either form or join their own groups in their own areas, and have dialogue with their council and apply pressure. Unfortunately, in Norfolk, we have seen a lack of co-production with NCC. It has been difficult. We have tried to engage with them to get a charging policy that is a new charging policy that is fit for purpose and does not break the law. That is incredibly difficult, but through the power of coming together and also using social media and local and national press, we are applying pressure and do expect you know, the findings of the judgment to be implemented by NCC. Svetlana, I don't know how much more detail you need or want, or if you want to add any more to what I've said.
Yeah, okay, thank you, Tom. Thanks very much for.
Do you want me to keep my camera on, or do you want me to go into the background again? Is that easier for access?
I have one little slide which I wanted to show people. So maybe, if you want.
Yeah, I'll just take myself off screen.
And but do correct me if I say something wrong. So I'll go back to just a second, my slides. So effectively, the Norfolk went through the process of changing its charging policy, as Tom said, and they had higher MIG, which they reduced to slowly to what the minimums are set out by government. And they also decided to take into account, as Tom said, enhanced rates of PIP and DLA, so which effectively penalizes, as someone said in questions and answers section, penalizes people with highest support needs and people who are not able to supplement their income by working. And so the judge said that policies that do that, so effectively targets or have an impact, a disproportionate impact on people who have high support needs and are not able to work. So it's specifically people on enhanced rates, daily rates of PIP, in higher rate component of DLA, or higher rate of attendance allowance. And in the support group of ESA, well, I don't know, well, I suppose pensioners are not, won't be on ESA, but so are officially recognized as not being able to work. So they are discriminated against. And if policy has a disproportionately negative impact on this group of people, potentially this policy could be also discriminatory. So what Tom referred to advice that the lawyers who ran this case gave about other local authorities. And the advice effectively says that the judgment, other local authorities must consider this decision. It doesn't straight away apply to other local authorities with similar policies, but they have to review their policy. And if it is discriminatory, so if it does have disproportionate impact on this group of people with high support needs who are not able to work, then local authority must change its policy, because the judge, the court already said that similar policies is discriminatory. And they have to obviously compensate everyone who has been discriminated by such policy. So they have to do this as part of their public sector equality duty and their duty not to breach people's human rights. So which policies could be discriminatory? So policies that reduce MIG to statutory minimum, policies that choose not to disregard higher rates of benefits, policies that have poorly functioning DRE system, because Norfolk really tried to argue that, well, people, if they have disability related expenditure, of course they can offset that and reduce their contribution. But we know in reality, getting your DRE recognized is a task in itself, and it's very difficult, and there are many restrictions. Some local authorities ask a lot of paperwork. Some local authorities say it has to be approved by social worker. Some local authorities would just say, well, we don't not recognize certain things as DRE, full stop. So potentially those local authorities that have those kind of charging policies and poorly functioning DRE systems could be discriminating. Also, what must be taken into account is, have they considered, when they drafted those policies, the impact on this specific group of people? And if so, and if they still decided to go with it, have they provided a good justification why they're doing this? Because again, Norfolk was trying to somehow justify their policy by saying that they will use this money to set up other services for this group of people, but it didn't really go down well. Another important point in this judgment is that obviously if people are in these situations, if you have high support needs and you're not able to work, so an ESA support group or universal credit, no work related requirements group, and you are now asked by local authority to pay your charges and persuaded for debt in county court, which local authorities can do, they will take you to court and ask you to repay the charges. You can raise the point that, well, I didn't pay, this policy is discriminatory, and the judge in that county court will have to apply this Norfolk judgment and consider. So, and also it's quite interesting that lawyers who looked who gave advice on this also looked at different disability related expenditure policies. And of course, this is all not tested area. So someone needs to bring legal challenge to really kind of clarify this. But they said that some DRE policies might be discriminatory. Things like blanket refusals to accept payments for general kind of activities, so going to a swimming pool, going to different classes, if there is a link, especially between well-being of a person and those activities. And I saw that someone put a question about specialist activities, which all must, of course, be part DRE because they are specialists. Now we're talking about general activities. If they improve well-being, they also could be argued as DRE. Council also said that blanket refusals to accept payments for meeting health needs. So what local authorities often do, they say, oh, well, you buy this, but this is actually available on an NHS. You paid for this expensive wheelchair. Well, but you could have got wheelchair from the NHS. So you buy this service, but actually you pay for your private counseling, but actually could be done through NHS. So potentially the guidance says that they should disregard, in the list of DRE, they talk about medical needs. So this is why probably it is, now we can make a case that no, even if items are available through the NHS, but there's a reason why a person is not using that, because those items should be allowed as DRE. And obviously transport costs. We, again, here there was a talk about local authorities not allowing transport costs per se. And technically speaking, they should allow costs which go above mobility component. So if a person, for example, uses mobility component to pay for mobility car, but then they also have other costs, or even maybe costs of someone driving them, then that should be classed as DRE, and policies that don't do that potentially could be challenged legally. So that, I'm stopping it there. And Jenny, I don't know if you want to come on.
Sorry about that. I was answering questions, so I hadn't been following the conversation.
So I think maybe we could choose some themes that that would be interesting to address. So I think there is a theme about young disabled adults continuing to live with their families, and families expected to pay for, well, for everything effectively, and some costs are not deducted. So for example, do you agree with that? And have you seen cases like that, Jenny?
Absolutely. I do know of a couple of people who act as appointees or deputies, I can't remember the term, and they will say that the total rent is this, there are a certain number of people living in the house, and we are going to allocate this proportion of that person's benefit monies to pay towards the household rent or the household bills. And that's a fair way of doing things, especially when you have someone who will use that to feel like they're contributing to the family situation. I think the key thing is rent is good, because that shows that it's a different type of expense. But with the household bills, the contribution to the food, that's more difficult, because the council or the government already say that a person needs to be left with a certain amount to cover those bills, the food, the activities, the clothes, regular bills. But rent is different. If they need to contribute to council tax, that's different as well. So that's looked at separately. So if a person's able to contribute to the council tax and the rent, that can definitely be taken into account on their financial assessment.
Yeah, thanks. And there was also another theme, which is what can be classed as DRI. I saw the question about kind of people with mental, people experiencing mental distress, people with mental health support needs. How could they argue for DRE? So I saw questions also about, like, could you claim, for example, wear and tear of furniture, which happens more often than generally. Could you claim things like vitamin D and other things like that? Could you claim activities like going to like hydrotherapy? And now I'm making it up because I'm not reading question and answers, but you probably saw the question as well. And I would say all of those are DRE. And you don't have to have like a prescription for example, some kind of vitamin or supplement necessarily to prove it is DRE. And actually the guidance, and it's true that local authorities can have very stringent policies, but the guidance and regulations are quite open to any expense that is related to your disability that is not covered by local authority providing you care and support being classed as DRE. So I don't know if you have any kind of views on that, Jenny.
I think if there's any things that you can think of in your specific case that you can argue is as a result of you being a disabled person, or the family member that you're supporting being a disabled person, and that has resulted in additional costs, put it to the financial assessment team. Go through that process of arguing, asking why something would or wouldn't be taken into account, and asking what proof they would like to see so it can be taken into account. There's that list is a very wide ranging list, especially that part where it says that it's a cost occasioned by disability, frailty, or health. I can't remember the exact wording.
Yeah, thanks. Do you have any tips in terms of what could be claimed as DRE by people with mental health support needs, or so something, or someone said people with learning difficulties, people with autism? I think it's we are gonna move into kind of labeling a bit, but I know some people even try to argue for coffee as DRE if coffee can be linked to well-being, and kind of helping with managing, for example, impairment, well, for or needs. Then yeah.
Absolutely.
Legal costs to challenge local authority how they do their financial assessments, for example, I think should be DRE.
Me too. So yeah, absolutely. I mean, it's difficult to look at a group of people and say these are the types of things that you could put down. It's really making sure that the individual is helped to think through that process about what could possibly be an expenditure. So first of all, what money is that person spending out, and then linking that spending to some type of well-being activity or something that prevents a deterioration in health. Is literally maybe looking room by room or day by day, looking at a pattern of spending about what things that person spends on, and then trying to link it. If there is a link, that's great. If there isn't a link, then it's probably not a disability related expense, but it might need to be thought of sort of outside the box. As I say, it could be that for one person, one thing is a disability related expense. For another person, it isn't.
Yeah, thanks, Jenny. I see that there are specific questions. Is this DRE? Is this DRE? And I think most of them answer is yes. And as Jenny says, if you can link it to why is it extra cost, and extra cost is because of disability, then it is a DRE. And if local authority doesn't allow that, then ask them why. And if they kind of still insist, then you might want to get advice and challenge that. There were, I'm trying to look at other questions that we haven't. So there were questions about residential care. We haven't planned to do anything, and I don't know how Norfolk judgment could apply to residential care. I think we might have to think about it, yeah, more creatively. I was trying to read. I don't know, Jenny, if there are any like questions or themes that you've come across that you wanted to comment on.
I don't think so. I think it's very much people are saying what their experiences of their local authorities have allowed and haven't allowed. And I think that's where challenges need to be brought if there is something that can be argued as a disability related expense, but the local authority has made an arbitrary judgment not to allow that. And again, I think it's the role of maybe campaign groups or disabled people's organisations to say to the local authorities, these are parts of the Care Act statutory guidance that say you need to think about not making people just live on the bare minimum. What are you going to do about that? How can we as disabled people and supporters help you make those changes so that you comply with the principles of the Care Act and the charging regulations, which is to support people's well-being and social inclusion, supporting people into training or education or taking up or retaining a job, and making sure that the guidance that's sent out by the local authority circular that's sent out by the government every year isn't taken as this is what it is and this is the line that we're going to hold everyone to.
Thanks, Jenny. I think there was also a theme which I just saw now about, especially kind of related to lockdown, about people not using all their hours and but still kind of having to pay contribution, and there were kind of questions about. There was a question about local authority of raising its contribution. And backdating it, but the person didn't really use the support. So this is quite a complicated thing to explain So I'm going to try. And if Jenny, I do a bad job, you're going to have to chip in. So, but as I said, it's not necessarily, it doesn't necessarily, if you reduce your care or do not use your care, it doesn't necessarily it doesn't necessarily mean you will reduce your contribution. So if there were weeks where you haven't used your direct payment or care at all, and local authority wants it back, you could say, well, and then I think you could legitimately make a case that you want the contribution for that week back as well. But if you, for example, use some of that care and the cost of it is above what you pay as a contribution, then you will unfortunately not be able to ask local authority to not to pay it or pay it back. And of course, the difficulty, especially with the pandemic, is that many people did not use a lot of support that they are entitled to. Many people accumulated quite a lot on their direct payments, and we know accounts, and we know local authorities will try and do their best to take it back. So I suppose the way to look at it is, if you haven't used social care support at all, you're absolutely within your right to ask for your contribution back. If you can identify weeks where you haven't used that support, and if it was for a good reason, obviously COVID was a good reason, then again, you can say, well, I shouldn't be paying this because I haven't used my support. If you use support, but it costed less than the contribution, you obviously can get the difference. But in all other cases, unfortunately, you'd have to pay the full contribution. In terms of kind of what to do with backdated direct payments, it's completely different story. And we have been saying for some time now at Inclusion London, it is a huge problem, and local authorities try and get back as much as claw back as much as possible. And we believe potentially this should be challenged legally. We don't think they can do that, especially when there was a good reason why that direct payment hasn't been spent. So it is, again, a gray area that needs to be clarified. But you could argue that you couldn't spend direct payment because of COVID. Now you want, or whatever, a young person you're looking after wants to do more, spend more hours doing more to compensate for what happened during COVID. And so you'd like, if you have a plan of how you're going to spend it, it might be harder for local authority to claw it back. Although, again, we know that there are, for example, when they operate prepaid cards, there are systems that just do it automatically, and you have very little control over it. So I don't know, Jenny, if you have anything to add to this.
No, sorry, I was trying to answer someone else's question again in the chat. But I would agree that if someone's not been able to access services because of the pandemic, it's essential that people don't pay for what hasn't been, they haven't been able to access.
Svetlana, may I come in on a slightly different point?
Yeah, of course. Yeah.
I'll just put my video back on. Hopefully you can see. I just wanted to pick up on something that you and Jenny picked up on earlier about coming together and getting support from your DPOs or forming a group. It's really important, because what we've found in Norfolk is that there's 3,200 people affected by the judgment in Norfolk. They are disabled people. They're now owed £1 million, roughly £1 million, and only a third of them so far have been paid back. And obviously the judgment took place in December, and we are fighting hard to make sure that the rest of those disabled people get paid back in a way that they need to be paid back, because to start with it was just we'll put money back into their support accounts, their care accounts. That's not acceptable. It needs to be how the disabled person wishes to be paid back. And this is something, you know, that you're only going to achieve by applying pressure within, you know, support groups. If anyone else wants to follow what we're doing, we are on social media, both Facebook and Twitter. So just search for JRIMG and you'll find us, or drop us an email as well. But I'll stop there because you've got limited time left.
Thanks very, very much, Tom. And yeah, it's absolutely important that we come together and challenge this system. There was a question about local authority not wanting to review. It's absolutely could be challenged that they don't want to review their policy in line with SH. They have to do it as part of their public sector equality duty. And if this is the case, then maybe do find gosh, this is an abbreviation that I still haven't mastered, Tom. JRIMG. Find them, and also there are organizations like Lead Day and Cascader that help from a legal side to implement the judgment. So it might be worth contacting them as well, or you can obviously contact us and we'll put you in touch. So we will send everyone an email with links, some of the links to the judgment and guidance that we mentioned. I think we sent copies of presentation. If not, we will do that. The recording will make recording available. I don't know how our YouTube worked. We tried to stream it, and if it worked, then we will keep it there. We aim to make it available to everyone who wants to challenge their financial assessment. So it will be like a tool to help people. So thank you everyone for joining us, and have a good evening, and please do come together, find local disabled people's organizations, and we need to try and challenge in individual cases, but also at a bigger picture, because we really do not want disabled people paying for essential support that they need out of their benefits. Thank you and bye. And thanks to Jenny, and thanks to our interpreters, and Norma, and Tom. Thank you, everyone.
Svetlana, I just had a thought. Do you want me to add the social media links and send them over so you can put them in the email?
Yeah, if you, yeah, that would be great. I think if people start like following you and joining, would be good, wouldn't it? Yeah.
I will do that.
I haven't even looked at the chat. I don't know what is going on there. So.
No, but thank you very much.
Thanks, Tom.